As you are aware, in 2013, the London Court of International Arbitration made an award in favor of the Belize Bank that it could recover the amount due under a loan note. That loan note had been challenged by the ACB all the way up to the Privy Council, and the Privy Council ruled that the loan note was valid. Notwithstanding the award and notwithstanding the decision of the JCPC, the Privy Council, the government objected to paying, and therefore we had to apply to the court in Belize to enforce against the government. The Supreme Court refused the application, and in the Court of Appeal, the majority refused the application. Mr. Justice Blackman dissented and said that we could enforce. So we went to the C.C.J. This morning, the C.C.J. handed down its judgment saying that the Belize Bank can collect on the award from the Government of Belize, and therefore we are supposed to write the government, and the government is supposed to pay. If the government does not pay, then we begin the enforcement proceedings against the government.
What would the enforcement proceedings entail? Do you have an idea?
Yes, the enforcement proceedings would be, first we will ask the registrar to issue a certificate in the amount that is due on the award. After that amount is due, we would serve it on the financial secretary, and he would be required to pay it. If he does not pay it, then we would commence proceedings in the court for his imprisonment or the imprisonment of the Minister of Finance, because the CCJ was very clear that the Constitution provides in Section 115.3 that in circumstances like this there is an obligation on the Minister of Finance to go to Parliament to get approval to pay the money, because the court has ordered that it should be paid. And if they refuse to obey the order of the CCJ, then there is no other recourse for us but to commence proceedings for their imprisonment.